This is a sad tale of a farming family, the Habberfields. It's centered around the estate of the late Frank Habberfield and the family farm Woodrow in Somerset, worth around £2.5 million. The main characters in this case were Frank's widow, Jane, and the daughter, Lucy. They had 3 other children, 2 of whom featured in this case, Andrew and Sarah. The other didn't feature very much. This case will rip the family apart, pitting mother against daughter, with the rest of the family having to take sides amid tensions going back many years. The main issue in the case was Lucy's claim that her father Frank had made assurances to her that he would leave her the family's farming business. She said that she had relied on the assurances, working long hours for some 30 years on the farm, taking very few holidays with little pay. But when Frank died, it turned out that he owned the farm jointly with his wife Jane. Lucy was left out in the cold, and that meant that all those years of early morning rising at 4:30 a.m. to milk the cows had come to naught. She decided to bring this claim for Woodrow farm against her mother. The saga would run for many years, with the judgment initially going against the mother, and then she appealed to the Court of Appeal. I shudder to think what they must have spent on this litigation. This was a very hard case for all involved. There was Lucy, who gave 30 years of her life to the farm. There was Jane, her 82-year-old mother, who would have to leave her home of 40 years. Would the Court of Appeal agree with the first judgment? Or would they allow the mother's appeal to succeed? Is there anything we can learn from this case? The legal issues. For Lucy to succeed in her claim for the farming business, she would have to show 3 things. 1, that Frank made assurances to her that she would get the farming business. But since it was jointly owned with Jane, Lucy would have to show that Jane was fully aware of those assurances made to her by Frank. 2, Lucy must have relied on the assurances made by Frank. And 3, she must have suffered some detriment as a result of relying on those assurances made by Frank. The cases show that for these kinds of assurances to amount to what is technically known as proprietary estoppel, they have to be firm and clear assurances. What amounts to sufficient clarity in a case of this sort is hugely dependent on the context, of course. However, the promise must be unambiguous and must have been intended to be taken seriously. We're not talking about off-the-cuff remarks. As one judge said, taken in its context, it must have been a promise which one might reasonably expect to be relied upon by the person to whom that promise is made. We'll start by looking at the initial judgment before we take a look at the Court of Appeal decision to find out whether Jane would be successful in overturning the judgment of the lower court. The background. From 1975, Frank and Jane farmed Woodrow Farm in partnership. It consisted of a farmhouse and some 116 acres of farmland, together with farm buildings. Lucy began working full-time on the farm on leaving school. It was her enthusiasm for dairy farming that persuaded Frank to restart dairy farming, which had ceased in the early 70s. From 1983, the dairy farming became the cornerstone of the business. In 1989, Frank and Jane bought a further 104 acres of land at Mudford. The farming business for most of the relevant period until 2015 concentrated on dairy farming. Although others worked on the farm, without Lucy's work there would have been no dairy farming at Woodrow. Since 2015, the business has been based on beef cattle and arable farming. The assurances made by Frank. The assurances which Lucy relied on began in about 1983, shortly after Lucy left school and went to work full-time on the farm. Further assurances were made in about 1985, again in late 1980s and in 1992. Although the precise words of the assurances would vary, the judge found that in substance, Frank had assured Lucy that if she continued to work on the farm, then after he couldn't run it anymore, the farming business would be passed to her, but with some qualifications. And the first was that some land would be made available for Andrew, his son, who had built up a machinery and contracting business which he ran from Woodrow. The second qualification was that some provision would be made for her sisters. And the third was that title to the farm and the farmhouse would not necessarily be transferred to Lucy whilst her parents were living. Among the assurances were words to the effect that Lucy was working on the farm for the eventual benefit of her children. The judge said the meaning of the assurances was that Lucy would receive not only the dairy farming business, but also ownership of the farm itself in due course. He also accepted that Frank's assurances were made with Jane's knowledge and authority. That was crucial to Lucy's case. The detriment suffered. Remember, I mentioned earlier that you have to prove that you suffered a detriment in this kind of case. Well, the judge found that part of the detriment that Lucy suffered was her work on the farm, including long hours, low pay, and few holidays. Another part was her commitment to farming at Woodrow rather than going elsewhere and building a successful dairy farming business on her own account. In particular, in 2006, there was the possibility of a farming business near Taunton becoming available for rent. By that time, Lucy had 3 children with her partner, Stuart Parker. They didn't tender for the farm because Frank persuaded them not to on the basis that Woodrow was their future. He encouraged them to stay for the benefit not only of themselves, but also for their children. As a result, they never submitted a tender for the farm in Taunton. In 2008, Frank and Jane made an offer to Lucy. The offer was that there would be a new limited liability partnership to run the farm, in which Frank, Jane, and Lucy would be the partners. Stuart would be taken on as an employee on a 2-year trial basis, and after that, they would consider bringing him into the partnership after her parents' death. Lucy would end up being the owner of the farm after her parents' deaths, although some land would be passed to her brother Andrew and some provision made for her sisters Emma and Sarah. Lucy rejected the proposal. Her reasons were twofold. First, she wasn't happy about the offer relating to Stuart. She felt her parents had gone back on what they had originally said. Second, as one of 3 partners in a partnership with her parents, she wouldn't have been in control, and her siblings' interference in the farm through her parents would continue. With the benefit of hindsight, perhaps it would have been better if Lucy had kept her cool and tried to negotiate a better offer with a closer involvement for Stuart. But that didn't happen, no doubt in part due to Lucy's temperament and attitude, but also that of her parents and the influence of her siblings. Indeed, the whole family was said to suffer from a short temper. Plus, the offer was not presented as open to negotiation. Lucy's departure from Woodrow. Following the rejection of that offer, both Lucy and Stuart continued to work on the farm, with Lucy staying put at Woodrow because she hoped she would get what she wanted in the long run, and staying was the way to do that. As Frank's health deteriorated, family tensions continued to mount. Those tensions boiled over in October 2013 when there was a fight between Lucy and her sister Sarah in the milking parlour. Lucy and Stuart resigned the following month. Sarah and her husband took over the running of the farm and stopped milk production in 2015, moving on to beef cattle farming. Frank died in 2014 and Lucy began her claim in June 2016. She asked for the farm to be transferred to her, but she did make a concession that she was happy for the judge to make a provision for her mother Jane to continue living at Woodrow Farm for the rest of her life. At the time of the trial, Jane was 81. The judgment. The judge said Lucy's parents intended and Lucy understood that the farming business would be hers in future after Frank couldn't run it anymore. Frank intended her to understand that the reward for her commitment to dairy farming at Woodrow was that the farm would be hers in the future. He concluded that Lucy had suffered detriment by relying on the assurances, so she should be compensated for the detriment she had suffered. The detriment she suffered can be summarized as lower pay than she could reasonably expect for her work, long hours, few holidays, and the continued commitment to Woodrow. This applied for all the time she was at the farm, just under 30 years. The detriment also involved her commitment to farming at Woodrow rather than somewhere else. Lucy had become a highly skilled dairy farmer, and she could probably have got a farming tenancy somewhere else long ago. but instead she positioned her working life based on her parents' assurances. That was the main detriment that she suffered. The whole farm was worth 2.5 million. The judge made allowances for land to be given to Andrew, who was running a machinery business on the farm, and for legacies to be given to Lucy's sisters. Ultimately, he decided that Lucy should receive a cash payment of the value of the Woodrow farmland and farm buildings, but excluding the farmhouse, and this together came to £1.17 million. It was to be paid in cash rather than by a transfer of the farm to her. The judge felt that a transfer would force Jane to leave her home. His view was that a cash award would at least allow for the possibility of the family raising the money without having to sell the whole property. The judge rejected Jane's argument that the payment should be deferred until after her death. He preferred to give Lucy the clean break that she wanted so she could go and start her own farming business. But that wasn't the end of the case, as Jane appealed the decision. What were her grounds of appeal? Would the appeal court overturn the decision? Let's find out. The law regarding appeals. An appeal court can only overturn the judge's decision in few circumstances. The main one being if he got the law wrong. The main prongs of the appeal. There were a few prongs of attack. Among them, Jane argued that the judge had not taken into account the benefits that Lucy had received whilst working on the farm, including the babysitting that Jane did for her. She argued that the award was not proportionate to the detriment that Lucy is supposed to have suffered. She also said that the award would leave her destitute after the payment to Lucy. The whole farm, she said, would have to be sold, including the farmhouse where Jane and Andrew lived, and also the land at Mudford where Andrew had his machinery business. This meant that not only would they be deprived of their home, but Andrew would lose the base for his business. Jane argued that the financial award to Lucy should be deferred until after her death. After all, Lucy was not expecting to turn her own mother out of her own home. But that would be the result of the judge's order that the payment should be made immediately. Jane also argued that the sale of the farm would incur a capital gains tax liability, whereas if it was sold after her death, there would be no capital gains tax liability and also no inheritance tax. It would be much more tax efficient to sell the property after her death, she argued. Therefore, the payment of the award should be deferred. The decision. Delivering his judgment, Lord Lewison disagreed. He said it was important not to lose sight of the fact that you couldn't put a value on the 3 decades of her life that Lucy had spent on the farm. Had her expectations been met, she would have been in control of the farm in 2008 at the time of the offer. In fact, she stayed on another 5 years. His lordship said that the order made by the judge was entirely within his discretion to make, in spite of the seeming tax inefficiencies. He also didn't accept that Jane would be left destitute by the award. The evidence, he said, showed that even after the sale, Jane would have enough left over to both house herself and to make up the shortfall in her income. It wasn't an easy decision for his lordship. On the face of it, it seems hard that an 82-year-old woman should have to leave the house which has been her home for over 40 years. However, the question for their lordships in this appeal was not whether they would have made the order that the judge made. The question is whether the order that the judge made was outside his discretion. His lordship ruled with some reluctance because of the hard outcome that it was not outside the judge's discretion. The other 2 appeal justices agreed. Accordingly, Jane's appeal was dismissed. Lessons from the case. This was a very hard case for all involved. Lucy, who gave the first 30 years of her adult life to the farm. Jane, her 82-year-old mother, who would have had to leave her home of over 40 years. The brother Andrew, who stood to lose the land on which he had built his machinery business. The sister Sarah and her family, who had built a beef cattle business on the farm. It was an impossible situation, and this happens more frequently than you might think. This case underlines the importance of dealing with succession issues for your family farm or family business. There are always expectations, particularly if some members of a family work in the business but not others. In this case, an attempt was made to deal with succession in 2008, but no agreement was reached. But that should not have been the end of it. Further attempts should have been made to continue the discussions and come to an agreement. In those situations, mediation can also be a good way to gather the family together to iron out all the issues and all the expectations and come to an agreement that all sides can live with. I can't imagine the toll this case must have taken on the whole family and the cost of the litigation, which his lordship had described as ruinously expensive. So the lesson from this week's case is get the family together and reach an agreement regarding your family business succession. I hope you found this week's case history useful. Make sure you join me next time for another fascinating case history.